So you have been arrested and charged with felony domestic violence, aka PC Penal Code 273.5, or corporal injury to a spouse or cohabitant. And you may be wondering, what exactly does the prosecution have to prove to convict me here? I'm going to be doing a deep dive on exactly that topic so that by the end of this video, you understand the 3 things that the prosecution must prove in order to convict you. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at a restraining order hearing and win. So if in addition to dealing with this arrest, dealing with a criminal case, you were also served with a restraining order, make sure that you get your free first class in the course via the link down below. Okay, so let's jump right in. Let's talk about exactly what the prosecution needs to prove in order to convict you of Penal Code 273.5a, corporal injury to a spouse or cohabitant. In any criminal case, in order for the prosecution to convict you, for you to have a criminal record because of this case, they need to prove certain facts. Now, these facts are called elements. You can think of these elements as a checklist, or if you like to bake, as ingredients in a cake. For each element, the prosecution has to prove that you are guilty beyond a reasonable doubt. It's not just looking at all the elements together and seeing, do I have a reasonable doubt here? If they fail on even one, then their whole case falls apart, just like if you forget an ingredient of a cake. Now, what is beyond a reasonable doubt? Beyond a reasonable doubt is proof that leaves you with an abiding conviction that a fact is true. It doesn't mean eliminating all possible doubt, because everything in life has some possible doubt. It means that the evidence is so convincing that a reasonable person would make major decisions in their life based on it being true. Okay, so we know why elements are important. We know how much the prosecution has to prove them. Now let's go into what exactly they are for PC 273.5. There are 3 elements here. The first one is willful infliction of a physical injury. The second one is on an intimate partner. And the third element is resulting in a traumatic condition. All 3 of those must be proven in order for you to be convicted of PC 273.5. So let's jump into each element and go through exactly what it means, and I'll give you an example of each one so you can see how it might play out. Element 1, willful infliction of a physical injury. Now, we're going to deal with physical injury more when we get into resulting in a traumatic condition, the third element, but let's talk about willful and what exactly that means. Willful means basically that you did something on purpose. For example, imagine that you are at a crowded party. Your partner accuses you of flirting with somebody else and you get into an argument with them. Eventually, you angrily turn away, bumping into them and causing them to lose balance and fall, resulting in a bruise. The question is, when you knocked into this person, was that willful? Did you do it on purpose? And in this case, there's some doubt here. And in this case, that element is going to really be in question. Maybe there are witness statements explaining that, although usually maybe you wouldn't want statements about this, that you were drinking too much that night and that you lost your balance on numerous occasions. Maybe immediately after this happened, you rushed to your partner's aid and you said, "Oh my God, I'm so sorry. I didn't mean to bump into you." No, ultimately, if a jury looks at this situation and they are not convinced beyond a reasonable doubt that you bumped into your partner on purpose, then the prosecution is not going to be able to convict you. Now let's turn to element 2, intimate partner. Now, intimate partner in the state of California is defined as a current or former spouse, cohabitant, dating partner, or co-parent. There's no clear, absolute legal definition of how many dates or what time period constitutes a dating relationship. In California, this is a gray area that is left up to the jury. A dating relationship in California is defined as frequent, intimate associations primarily characterized by expectation of affection or sexual involvement. Okay, so imagine a scenario where you met someone on Tinder. You go on a date, goes pretty well. You go on a second date. And during that second date, you get into an argument. Now, the allegations are that during that argument, you slapped your Tinder date in the face and scratched them with your nails, leading to an injury. So if the prosecution claims that this is a dating relationship, you really would have to look at, does this qualify? Is meeting someone twice frequent? Do you necessarily expect affection or sexual involvement on a second date with someone? And the answer to that is it is a question for the jury. There's no clear answer here. Now, if between the first date and the second date, the two of you had frequently communicated, you'd exchange saying, I love you. Maybe you had sex on the first date, and on the second date, perhaps the two of you had been long distance between the first date and the second date. Perhaps there is an expectation of affection and sexual involvement, but there's a lot of information that would go into this determination by the jury. And if the jury ultimately decides that this was not a dating relationship, then you cannot be convicted of PC 273.5. Now you may be thinking, okay, but obviously it's a crime to slap someone and scratch them with your nails, and you would be right about that. In this scenario, this person, the defendant, could probably be convicted of at least battery, assuming that this was done intentionally. But this distinction actually is really important for a few reasons. First of all, the way that laws are written in California are such that domestic violence cases have harsher potential penalties than non-domestic violence cases. For example, probation is longer. There's a requirement of taking domestic violence classes. There are certain pretrial diversion programs where you can avoid a conviction that are not allowed, although there are ways to get around it. They're not allowed for domestic violence cases. Also, notably, if this case were to go to trial, the prosecution may not charge you with battery. They may just charge you with PC 273.5. If they do that, and the jury decides that you are not guilty of that because there wasn't a dating relationship, they can't go back later and charge you then with battery or whatever else they think they should have charged you with. And the prosecution sometimes is strategic, and they will decide that they are not going to add these smaller crimes, are called lesser included offenses, because they don't want the jury to pick the less severe crime. And frankly, especially in misdemeanor or low-level cases, sometimes they just simply forget. They don't think about it that hard. You could end up with a situation where the jury fully believes that you slapped someone willfully and you scratch their face, but you have a complete acquittal. Element number 3 is a traumatic condition. A traumatic condition in California is defined as a wound or other bodily injury, whether minor or serious, caused by the direct application of physical force. We need a wound or some sort of bodily injury here, right? And this is actually, whether or not there's an injury, is typically what distinguishes you being arrested for a felony or a misdemeanor in a domestic violence situation. If the police can see any kind of injury, usually they're going to arrest you for a felony. As an example, let's say that you and your spouse get into an argument. And during the argument, your spouse alleges that you grabbed their arm, causing pain. However, when the police arrived, there were no visible marks. Your spouse didn't seek medical attention, and photos of your spouse the next day show that there were no marks there. The prosecution has a problem with element 3 because there is no injury, there is no traumatic condition here. And so they are not going to be able to convict you of PC 273.5. Now, they can convict you probably, based on these facts, of PC 243E1, which is domestic battery. Domestic battery can only be charged as a misdemeanor. It's basically harmful or offensive contact, but there is no requirement of an injury there. So this can be all sorts of conduct that doesn't result in an injury, slapping somebody, but there's no red mark, spitting in someone's face, but there is no injury requirement. But again, the prosecution, if this were to go to trial, they may not charge you with that. They may only charge you with PC 273.5, and if the jury has a reasonable doubt as to whether or not there was a traumatic condition, aka an injury, then they cannot convict you. I hope you found this video helpful. In the next few videos that I am planning on this series, where I do a deep dive into every single part of a domestic violence case, I will be going into more detail of each one of these elements, and of course there are also possible defenses like self-defense that I will be doing deep dives on as well. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.